Hi, I'm Bernie McCloskey and I'm a solicitor in the commercial litigation team here at MKB Law. I'm joined today by my colleague Emma Smyth, who is the Associate Director in our property team.
Hi, Bernie.
So today we're going to be discussing an issue that is very prevalent at the minute in light of the recent adverse weather that we've all been experiencing. And that is, to what extent is a landowner liable for property damage or personal injury caused by a fallen tree?
Yes, as everyone will no doubt be aware, following the rare red weather warning that was issued during the recent Storm Eowyn, and one of the specific concerns was dangerous driving conditions due to the risk of fallen trees.
I see that it was reported by the newsletter recently that there were over 1,800 fallen trees during the course of Storm Eowyn, which is a considerable amount of damage, which was over a relatively short period of time.
Yes, and I'm sure we've all seen the photographs of the house in Newton Abbey where the tree fell through the roof. We can only imagine the devastation and distress that would cause, which would only be compounded by the question of who actually is liable.
I think that's right, and I think it's probably fair to say that most people would assume that the owner of the tree in that situation would automatically be liable for any damage caused as a result of the tree falling. But the law surrounding the liability of landowners in those circumstances is actually not straightforward. So whilst the default position is that the landowner can be held responsible for damage from a fallen tree, the determination of liability in that situation will depend largely on whether the landowner took reasonable steps to inspect and maintain the tree, and whether any defects that were discoverable through such inspections were actioned.
Yes, and in your practice area, Bernie, have you ever came across any relevant case law in relation to fallen trees and the issue of liability?
Yeah, so I have recently come across a case that deals with this point, which was a 2006 England and Wales High Court decision in the case of Paul v Viscount Asquith of Morley. So the claimant in that case was riding a motorcycle along a road in Somerset when he collided with a fallen ash tree and sustained injuries. So proceedings were subsequently issued against the owners of the tree on the basis that they were negligent in their care and maintenance of the tree. But as I touched on before, the key factor in determining liability in that situation is whether the landowner knew or ought to have known that the tree was likely to fall and cause injury. So determining what the landowner knew or should have known in that regard will involve an assessment as to whether any inspections were carried out by the landowner. If inspections were carried out, how often were they carried out, what did they entail, and so on. It'll also likely be relevant to consider what maintenance was carried out to the trees as a result of the inspections to mitigate the risk of being held liable.
Yes, thanks, Bernie. And as you're aware, we advise a number of property developers, and I suppose they might want to ask us, well, if we were advising them, what would constitute reasonable inspection and maintenance of a tree? Yeah, I think that that's definitely a relevant consideration for developer clients. What constitutes reasonable inspection and maintenance on the part of the landowner may vary depending on their specific circumstances. For example, most of us would have perhaps one or two trees within the boundaries of our own homes, and it could perhaps be argued that a regular visual inspection of those trees by us, in addition to perhaps yearly cutback works, could be considered to be sufficient and reasonable in those circumstances. But that could potentially be contrasted with with perhaps owners of much larger areas of land with numerous trees that would apply to most of our developer clients, and particularly ones that may be growing along the roadside. I think that's what the court would look to in that situation. As to what would constitute reasonable inspection and maintenance could be much more onerous. So the interesting point actually in the case of Paul that I mentioned earlier was that the owners of the tree in that case had actually employed an independent forestry contractor to undertake inspections of their trees, and many of which were along the roadside in that case. However, it was determined that even though they had
carried out the inspections. They were not carried out by what was referred to in that case as a competent level 2 inspector. So in actual fact, whilst they had carried out the inspections were deemed to be inadequate in the particular circumstances of that case, and the owners were held to be liable. So the reason for that and for the court's determination in that case was that it was determined that a competent or level 2 inspector would have appreciated that a tree of the type in question is particularly prone to a certain structural defect, and that would have prompted a more detailed inspection of that tree, which in turn would have uncovered the issue that then eventually resulted in the failure of the tree in that instance.
Do you want to talk a bit more about that?
Yeah, I think that actually brings us nicely on to that point, which is that in addition to the inspection and maintenance requirements on the part of a landowner, another important factor in determining liability will be what was the ultimate cause of the failure of the tree, and should it have been picked up through inspection. So in the Paul case, it was determined that the defect would have been picked up had an adequate inspection been undertaken. However, you could foresee that if the cause of the failure of the tree is not something that could be picked up on, no matter what level of inspection was carried out, and no matter what experience level of the contractor, it's difficult to see how a landowner could be held liable in those circumstances.
Okay, and we focused a lot there on liability and issues around fallen trees, but for your average homeowner, is there anything that they could be doing to prevent damage being caused by fallen trees, or any practical advice we would give them?
Yeah, absolutely. I think that it is a concern for most homeowners. I think particularly in light of the recent events in the storm. So I think, taking into account the fact that liability on the part of the owner of the tree will largely be dependent on whether or not they knew or ought to have known of any defects, what you could do as an owner of a neighbouring property is that you may want to consider carrying out visual inspection yourselves of any trees that adjoin your property, without, of course, straying into any issues of trespass or anything along those lines. But if there is an issue that you can see from your visual inspection, I think it's advisable to write to your adjoining landowner to put them on notice and request they carry out an inspection and any required maintenance as a result of that. That would be an important factor then down the line if there ever was an issue, if the tree had fallen. You could rely on that correspondence as evidence that the landowner knew that there was an issue or should have taken appropriate action to prevent the damage that has occurred. So there's actually an interesting, I suppose, connected issue which relates to situations where tree roots can encroach on a neighbouring property and result in damage. So the damage in that instance maybe is coming from structurally below the ground as opposed to the tree falling. I actually think that may be something actually that's more prevalent for your clients, Emma, in terms of the development potential of land. If there's encroaching tree roots, particularly if they're belonging to a tree which is perhaps subject to a tree preservation order.
Yes, that's an important point. In Northern Ireland, tree preservation orders are commonplace. There is legislation enacted which protects certain groups of trees or woodlands, and they're protected because their removal would have a significant negative impact on the area and its biodiversity. And trees contained in the conservation area are actually automatically protected.
That's really interesting. So it's legislative provision. And what is the effect of a TPO? If you were advising a landowner, what advice would you give them as to the effect of that?
Well, it would be around the breach of a tree preservation order. And we would sort of be saying that it would be an offence for a landowner to cut down, top, loop, uproot, or any destruction or damage to a protected tree without the consent of the local council. And in terms of the effect, if you did commit a breach of a tree preservation order, it can result in a fine of up to £100,000 or an unlimited fine if it is prosecuted through the Crown Court.
It's quite a hefty penalty there then for breaching a TPO.
Absolutely. I suppose then the question connected to, storm damage and protected trees. So what if a protected tree was damaged during the recent adverse weather conditions?
Yes, like what could a landowner do in that instance?
Yeah.
Without breaching the TPO, for example?
Absolutely. So there is an exemption under the legislation, and work may be carried out by the landowner without obtaining consent from the local council. It is, however, recommended to make the local council aware of the proposed works prior to them being carried out as a belt and braces approach. The likes of minor branches that have been separated from protected trees can be easily cleared up. However, if there's damage that's more serious, such as a cracked trunk or major branches having broken, it would be advisable to consult with a professional tree surgeon or qualified arboriculturalist.
That's really interesting, actually, because that's really in keeping with the principles in terms of the negligence on a landowner's part, because the recommendation there is to consult with a professional tree surgeon really as soon as possible to make sure that you're complying with your duties in that regard, isn't it?
And if any tree is subject to a TPO, and if it's removed or uprooted or destroyed, it is the landowner's responsibility under the legislation to plant another tree, and it should be of an appropriate size and species and at the same location. It should be planted as soon as reasonably possible, and the TPO then will apply to the newly planted tree. So the duty to replace the tree is on the relevant landowner. So I suppose on a practical basis, if any homeowners or landowners had any protected trees that were damaged during the storm, there is a duty on them to replant that particular tree.
Okay, well, that's been really interesting discussion. Emma, thank you so much for joining me.
No problem at all. And it is very topical at the moment. I'm sure a lot of people are still trying to work through the effects of the storm.
Absolutely. Well, hopefully that's the last one we'll see for a while. We're heading into brighter days. Okay, thanks so much, Emma.
Thank you.